Under USERRA, employers must provide service members employees with reemployment rights and benefits when the employee is absent from work because of his or her service in the uniformed services if the service member meets all eligibility criteria. Understanding the general provisions of USERRA is essential for both employers and employees as it ensures that service members can fulfill their military duties without sacrificing their civilian careers. These provisions highlight the foundational elements that protect against employment discrimination, guarantee prompt reemployment, and uphold the benefits of employment for service members. By comprehensively understanding these provisions, participants will be equipped with the knowledge needed to support USERRA compliance. When the Uniformed Services Employment and Reemployment Rights Act, USERRA or the Act, became law on October 13, 1994, it was intended to encourage non-career uniformed service, minimize disruption to individuals performing service and their employers, fellow employees, and communities, ensure prompt reemployment of those who have served or serve in the uniformed services, and prohibit discrimination and/or retaliation based on an individual's service or affiliation with the uniformed services. 38 U.S.C. Chapter 4301 through 4335. The permanent law written and codified by the United States Congress. Written for all U.S. employees. 20 CFR Part 1002 is a plainly written portion of the regulation and has been written in an easy-to-read organized question and answer format. It was written for public and private employees. 5 CFR Part 353, similar to 20 CFR but specifically written for federal employees. Is the regulation also written in an easy-to-read question and answer format? Service members that are leaving civilian employment. DoD policy states that service members will provide verification of absence due to uniformed service to civilian employers upon request, regardless of the duration of the service-related absence. Documentation can be requested, not required. Notification can be verbal or written. Service members returning to civilian employment. Law states that employers can require documentation following service exceeding 30 days to be eligible for increased benefits, like paid leave. This documentation must not be used as a reason to delay reemployment. Used to verify timely application and eligibility for reemployment. Service member qualifications. To be eligible for reemployment under USERRA, service members must meet 6 key requirements. Each of these gates serves as a checkpoint to ensure the service member's eligibility for reemployment. 1. Hold a position of employment. 2. Leave for the purpose of service. 3. Prior notice. 4. 5-year cumulative limit. 5. Eligible discharge. 6. Timely application for reemployment. Service member rights. If service member is absent for fewer than 31 days, the service member should be available for the next full shift will be at least on the next day following safe travel and 8 hours rest. If a service member is absent for greater than 30 days, the service member should be available for the next full shift will be as soon as practicable, usually within 2 weeks. Employer obligations. Prompt reemployment should be with the benefits and rights, and should be the next full shift will be as soon as practicable, usually within 2 weeks. The reemployment position should be that the employer reinstate employee to the appropriate reemployment position, and the employee should be restored with the appropriate pay, seniority, and status. How reemployment position is determined. Under the intent of USERRA, the employee is entitled to reemployment in the job position that he or she would have attained with reasonable certainty if not for the absence due to uniformed service. This position is known as the escalator principle. It may reflect a promotion, a higher wage and/or step of pay, or it may reflect a position that is in layoff status. The escalator position reflects with reasonable certainty the pay, benefits, seniority, and other job prerequisites that he or she would have attained if not for the period of service. Following a period of service of more than 90 days, the employee must be reemployed according to the following priority. 1. The escalator position or a position of like seniority, status, and pay period, he or she must be qualified to perform the duties of this position. The employer must take reasonable efforts to help the employee become qualified to perform the duties of the position. 2. Reemployed. In the position in which he or she was employed on the date that the period of uniformed service or in a position of like seniority, status, and pay period, the employee must be qualified to perform the duties of the position. 3. Reemployed in any other position that is the nearest approximation first to the escalator position and then to the pre-service position. Status in the reemployment position could include opportunities for advancement, general working conditions, job location, shift assignment, rank responsibility, and geographical location. One thing to note is that if an opportunity for promotion or eligibility for promotion that the employee missed during military service is based on a skills test or examination, then the employer should give him or her an reasonable amount of time to adjust to the employment position and then give a skills test or examination. Qualification training. The employer must make reasonable efforts to qualify the returning service member and ensure that the service member is entitled to training they would have received if not for their military service. Entitled to assistance to become certified would have received if not for the military service, along with any missed training opportunities or promotion opportunities. If the employee has a disability that incurred in or was aggravated during the period of service of uniformed services, the employer must make reasonable efforts to accommodate that disability and to help the employee become qualified to perform the duties of his or her reemployment position. If the employee is not qualified for the reemployment position in the escalator principle because of a disability after reasonable efforts by the employer to accommodate this disability and to help the employee to become qualified, the employee must be reemployed in a position according to the following priority. The employer must make reasonable efforts to accommodate the employee's disability and to help him or her become qualified to perform the studies in one of the positions. A position that is equivalent in seniority, status, and pay to the escalator position. B. In his first week, they determined a position that is the nearest approximation to the equivalent position, consistent with the circumstances of the employee's case. In terms of seniority, status, and pay period, a position that is the nearest approximation to the equivalent position may be a higher or lower position, depending upon the circumstances. Affirmative defenses of the employer. The employer is not required to reemploy SM if the employer's circumstances have changed and make it impossible or unreasonable. Assisting the service member in becoming qualified would impose an undue hardship to the employer. The employment position was for a brief, non-recurrent period with no expectation of reemployment. These are very narrow affirmative defenses that the employer may assert. Seniority-based benefits that the service member may be entitled upon return from service. Benefits based on longevity, reasonable certainty. It would have been earned but for military service. Employer practice and policy. An example, rate at which someone earns vacation time. Non-seniority benefits. Short-term compensation for work performed. Paid leave and differential pay. Leave accrual, performance bonuses. Furlough or leave of absence benefits. These types of benefits should be the most favorable treatment for any other comparable leave. Waiver of benefits by the service member may knowingly waive entitlement to benefits but not reemployment. For military members, the first step is typically to consult with your chain of command. Military members and employers may also contact DSGR and ask to work with an ombudsman. The U.S. Department of Labor Veterans, Employment, and Training Services authorized by Congress to investigate and resolve complaints of possible USERRA complaints. If you file a complaint with VETS and VETS is unable to resolve it, you may request that your case be referred to the Department of Justice for representation. Similarly, federal employees may request the unresolved case to be referred to the Office of Special Counsel for representation. You may also bypass the VETS process and bring civil action, which is a private attorney, against an employer for possible violations contrary to the intent of USERRA. Thank you for your attention during this non-ombudsman training to familiarize yourself with ombudsman-type issues associated with USERRA. You should contact your Ombudsman Director if you have any questions or need help in facilitating the questions of a service member. Immediate assistance may also be received by contacting National Headquarters also.